2, 1.
Welcome to Made for More Living.
One small step for man.
With Johnny Jennings.
Kick the tires and light the fires, Big Daddy.
The fastest and most exciting hour of news, events, and real estate in Northern California.
And this is a fact that was proved.
Online at madeformorerealty.com.
Does everybody know what time it is?
Get ready. Here we go.
So when I got my real estate career, I wasn't scared of brokers. But now, after having done this for a while, they're kind of like real estate cops. They're the ones that lay down the law, issue fines, tell agents what to do. And today we have it's an absolute honor to have my dear friend Ryan Rosas on the show.
Do you carry a badge?
You should.
I should carry a badge. That would be fun.
Yeah.
Nobody would.
Are you armed when you go talk to realtors?
Armed with knowledge.
There you go. That's something a lawyer would say.
Yeah.
That is something a lawyer. So we got Ryan Rosas, designated managing broker for eXp Northern California and eXp Commercial, right?
I'm an officer for commercial. I'm not the designated broker.
Oh, you're not?
Yeah.
Okay. I'm sorry.
Yeah. It's a regulatory title. So it's,
all good. But you're on the show today. And, so quick story as far as cops go. Did you hear I almost got pulled over the other day?
No.
So I'm horrible.
You almost got pulled over.
How do you
Almost. Yeah, it literally.
I almost get pulled over every single day. If a cop was nearby, boom.
Exactly. So I'm on my phone. So if it was Valerie, she would have gotten a ticket. I'm on my phone at a stoplight. The stoplight's red. I'm responding to text, doing something. All of a sudden, like out of the side of the glass, I'm like, what the heck? Something's blinding me. Turns out a cop had pulled up next to me and was flashing his side lights at me. Uh-huh. And he told me to roll down my window. And so I roll it down. He's like, get off your phone.
Yeah.
Even if you're stopped at a red light, You're not supposed to be on your phone.
No phone in hand.
I'm like, oh, okay. I'd
say, hey, look around me. Everyone else at the stoplight is probably on their phone right now.
You got to break, though, because they can write you a ticket on that.
I know. I've had a ticket
It's true.
before.
I've had something similar happen to me where he yelled at me, get off your phone.
Yeah.
Were you driving the corporate
No, I
truck?
I was parked too, though. I was parked too.
Okay.
Yeah. I was at a red light or a stop sign, and he was mad. Yeah. This was years ago when they first...
They were more heavy-handed, I think, when it first came out.
Came out,
Now it's like, come on, everybody. I see teenagers driving with their phone on.
Yeah.
Well, we're so
I'm not saying it's good.
You know?
It's not safe.
It is not safe at all.
Yeah.
We are phone dependent, though.
Yeah.
Anyways, it's a thing. But so you are kind of like that version for real estate agents, and there to help people. Like, again, law enforcement is definitely there to help, but you probably see a lot. How many agents roughly do you interact with on a given month, week?
Oh, well, we oversee 10,000 agents in the state. So how many I engage with, I couldn't even put a number on that. I mean, tons. Yeah. And some things are more complicated than others. Some things are very easy. It's just a quick response, and some things I go to court for, So,
oh my gosh, yes. I know you just wrapped up a
long trial.
A long trial, and you say most of the time they don't go to trial.
That's right. Yeah, most of the time, 90% of the time, things that are brought up in litigation get settled out. But occasionally there is something that goes to trial, and I just came off a 5-week trial. I've got another one coming up probably in the next year or so. Yep.
Man,
yeah,
that's wild. You know that far in advance if it's going to trial?
Well, they have to, because you think of the logistics of witnesses, all parties that need to be there. The court essentially says we need to know dates that you're not available so that we can schedule the trial around everybody's unavailability. So they ask for stuff. They usually don't ask. I mean, I got asked for my time that I am unavailable for the rest of this year, for all of 2026 and early 2027. And so that's a very long stretch. It's typically not a request that's that long. So long. I'm like, well, I don't know what I'm doing that far in advance.
I don't know what I'm doing tomorrow.
I don't know, exactly.
2027?
Yeah.
Exactly. Okay, so I think it would be interesting for buyers, sellers, agents. What are people typically getting sued for? Like in your day-to-day, what are the top causes?
Well, it depends on the level. So if you're talking about like things like small claims, that typically involves deposits. Right.
One party not releasing the deposit?
One party not releasing the deposit, right? Because the escrow holder is a neutral third party, and they're going to say, hey, basically, you guys figure it out or you bring me a court order. So there's small levels like that. And then on the bigger levels, it's almost always to do with disclosures on some levels. Something wasn't disclosed appropriately. It was hidden. It was my agent didn't explain this to me, things like that.
They explained it, but they didn't explain it well enough.
Yeah.
Yep.
Yeah.
So let's go back to the deposits, because a lot of people think, hey, you know what? My contingencies are still in place. My agent said I'm protected.
Right.
I'm going to cancel the agreement.
Yeah.
And I'm going to get my deposit back.
That is how it's designed. I mean, when you look at the contract has contingencies in place that are designed to protect the deposit of the buyer, so that if the buyer cancels within the scope of cancellation rights, that the deposit should go back. But the reality is it takes two to tango. And so if the seller, for whatever reason, a lot of times it's emotional, right? They feel that they've been wronged by the buyer in some way, shape, or form, right? And so they're like, I'm not going to release the deposit, even though the deposit's protected.
Yeah.
And so they say, I'm not going to sign it. I'm not going to sign it. And so, yes, it's supposed to go to the buyer, but if the seller doesn't sign it, then the escrow holder who is holding those funds says, you got to figure it out.
So if Chicago Title is the escrow holder and both parties don't agree, what happens to the money? It just sits there?
It sits there. I mean, it can't sit there for too long. I mean, the escrow companies are regulated just like real estate agents. So it's in a trust account and it has to be maintained. But if there's no resolution to it after a period of time, it gets escheated to the state, essentially. But that's I mean, it's rare that happens, right? Because at some point, somebody, will take them to small claims court or something like that and get a court order that forces the release.
Yeah, but I think it's really important for, buyers, sellers, agents to know, just because contingencies are in place does not mean you're guaranteed to get that money back, to get that deposit back.
And I advise agents on that all the time, because they'll come in and they'll ask and they're like, well, what's going, is the deposit protected? And I said, from a contractual standpoint, absolutely it is. But let's talk about the reality of what happens out there in the real world, right?
Yep.
So
what about, because there is a limit. What's the limit in terms of the deposit that can be kept?
Well, it depends. The contract has an optional clause in there for liquidated damages. Liquidated damages is capped at 3% of the sales price. Mm-hmm. So depending on what that sales price is, the 3% can't go over it. And then there's a lot of misconception around liquidated damages as well. So people will say, so as an example, let's just, for the sake of numbers, let's say liquidated damages, the 3% is $30,000, but the initial deposit was $10,000. Well, that $10,000 becomes the limit now, right? It doesn't. There's not
up to 3.
It's not to up to 3. So if they put $30,000 in, that it's now subject to that. But if they only put $10,000 in, right?
What if they put $50,000 in?
Then it's capped at 30.
Okay.
It's capped at 30. And with liquidated damages, whichever party is claiming those funds. Typically it's the seller, right? Typically the seller saying, well, I want to keep the funds because of whatnot. And even if all the contingencies have been removed, the seller has to show what their costs are. So it's not automatically they're getting $30,000. They have to say, hey, listen, I was harmed because I had the movers coming to take me to Georgia where I was relocating to, and I lost my deposit on that house, which was $10,000, right? Things like that. So they have to be able to show. It's just not an automatic, well, you get all $30,000.
Love that. And so there's some gray there. Mm-hmm. But let's say they put $50,000 down, $30,000 would have been the 3%.
Right.
And both parties do not agree to release the deposit. Does the buyer get their $20,000 back and $30,000 chill in escrow, or?
Typically, the escrow holder won't do anything. Yeah,
okay.
Yeah. There is a provision in the purchase agreement, because if you think about the California Association of Realtors purchase agreement, it's a purchase agreement and joint escrow instructions. And the joint escrow instructions does have a provision in there that says that if there's a disputed deposit, one party can make a request of the escrow holder to release that deposit to them. And if the other party doesn't contest it within 10 days, the escrow holder can release it. But the key word there is that they can release it. They don't, right? They say, we don't want to be sued. We don't want somebody coming after us. We're just taking a neutral stance, right?
Correct.
Yeah.
Dude, I love having this conversation with you. You're like ChatGPT for real estate. So deposits, that's one way people get fired up and end up in small claims court is about the deposits. And the second thing you said had to do with disclosures.
Disclosures, yeah. And disclosures end up in both small claims, right? Hey, like the plumbing is leaking, right? And I had to get a plumber out here for $4,800. That falls into the scope of small claims, right? Mm-hmm. But sometimes it's a much bigger number. And agents have a duty to perform a visual inspection, right? And there's case law.
Is it AVID or AVID?
I call it AVID, but some people it's
Agent
tomato,
Visual
right?
Inspection Disclosure.
Yeah.
I say AVID.
Yeah. I say them both. I guess it depends who you're talking to, but
it's like Amex or Amex.
Right. Yeah. Exactly. Yeah. But that's well established in case law. The Easton case, where the California Association of Realtors and the Department of Real Estate basically created code, which is law, that says, hey, this is what the agent's duty is. And it essentially is what an agent can visually observe. But what happens is consumers, the buyers and sellers, they don't really understand that that's kind of the scope, even though it says scope of duty of these, right? All
even
that
though
stuff.
It's explained. Yeah.
Even though it's explained, it's not. And so what inevitably happens is a buyer, as an example, will come back post close of escrow and say, well, the agent didn't see this, right? Well, yeah, it's a sewer lateral clog. How,
Yeah, exactly.
they didn't tell me about it. It's like, well, how would they know that the tree root is in there, right? We see stuff like that all the time. And consumers will come to us and they'll want the brokerage to make it right. It's like, it's not, that's
buyer beware, dude.
Yeah. A buyer has a duty to perform inspections, to understand what they're purchasing, and to ask questions. They don't ask questions all the time. They get these disclosures and they just sign them.
Yeah, and then they end up buying something they didn't realize they purchased.
That's exactly right. Yeah.
Yeah. So we always tell. So a lot of the sellers I'm dealing with right now, they're like, I'm selling this as is.
Yeah.
Money's tight. I don't want to put
Sure.
anything into it. I'm selling it as is, and I always tell them, absolutely, totally agree. Yep. Every residential purchase agreement is an as-is sale.
It starts that way. Yeah.
But the buyer has the option to inspect the property.
That's right. Yeah.
And then they can submit to your request for
even
repairs.
if the buyer waives inspection contingencies up front, they can still have every right to perform those inspections, right? They just can't cancel based off the results of those inspections, but they can certainly do it. They can always ask for, renegotiate, ask for a repair request or a credit, and seller is in every they're well within their rights to say no, or not even respond. Actually, they don't even have to respond.
And if you're working with so let's say you're selling your house and you're working with an agent, make sure that agent gets their agent visual inspection disclosure out and to the other side as quickly as possible.
Very, very important, especially on the seller side. So if there is an agent representing the seller, the agent visual inspection disclosure is actually considered an extension of the seller disclosures. And a lot of times agents don't realize that. Yeah. And there is a contractual amount of time that the seller is supposed to provide disclosures to the buyer. Maybe the seller did all their disclosures in a timely fashion and their agent didn't do their inspection for 2 weeks.
That never happens,
right?
Ryan. Maybe at the other brokerages, not over here.
Right. And it opens up a window, right?
It opens up a window. Is it 5 days that they have?
5 passive days. Yeah.
What do you mean by passive?
So if anything new or material or disclosure comes in, the buyer always has 5 days to look at it. So in the contract, they have a certain amount of days to remove contingencies or do something. But let's say that time frame has already passed and something new comes in, or that agent visual inspection now gets delivered. They have 5 days to review it. But if they don't cancel based off of that within 5 days, they are deemed to have accepted it.
Got it. Mm-hmm. Okay. Perfect. Hey, when we come back, we're going to be talking about listing cancellations and how that works, because I know a lot of people out there are getting frustrated with their agent and wanting to cancel, and how to protect yourself if you're buying a house and if you're selling a house and there's repairs involved. Back after this.
If a movie has a 100% Rotten Tomato rating, you can be sure it's going to be a pretty good movie, right? Well, that's the case with Johnny Jennings and Made for More Realty. No, they don't have a 100% Rotten Tomato rating, but what they do have is over 1,000 5-star Google reviews. So it's pretty evident that a lot of people love the job that they are doing when it comes to helping them sell their home or purchase their next home. They're friendly to talk to. They're also very professional and can get things done fast, and for the most money possible. So if you would like their help, they'll walk you through every step of the process. No problem, easy. That's why they have, again, over 1,000 5-star Google reviews. Just Google Johnny Jennings with Made for More Realty and get more for your home.
This is Made for More Living with Johnny Jennings. Online at madeformorerealty.com.
Expired listings. These are listings or canceled listings. These are listings that failed to sell with their realtor. It could have been 1 week, could have been 2 weeks, could have been 1 year. But regardless, we're seeing an uptick of these houses that are failing to sell in the market that we're in right now.
Yeah.
And just because of the level of marketing Made for More does, we've seen an increase in the number of people reaching out to us saying, hey, I heard your ad on the radio. I saw your billboard. I saw you on YouTube. Can you help me?
Right.
And then we look up the address and they're listed, right? And so what we're seeing is a lot of people who maybe didn't do their due diligence, picked a family friend, went with the cheap option, and now they're regretting their decision and they're wanting to cancel the agreement.
Yeah.
So what would your recommendation be, Ryan, for somebody that calls us, and how should, like from a broker's perspective, from the real estate police, how should we handle that?
Yeah, it's tough for us because if they are in contract with somebody, they have an active listing, that's agency relationship, right? And so we're regulated by the Department of Real Estate, and they define agency relationship and what we can and cannot do. So we can't interfere with somebody else's agency relationship. So if a consumer calls Made for More and says, hey, I'm working with somebody, that should be the first thing we do is say, hey, listen, I would love to work with you, but I can't work with you while you're working with somebody else because they have exclusive rights to do this. So you have to have a conversation with them first about, are you going to continue working together or not? After you have that conversation, and if you guys choose not to work together, then we're happy to go down that path with you.
So do we need to wait till we have like written proof that the agency's been canceled?
Yeah, I mean, if they tell you, I mean, you don't necessarily need to have the cancellation of listing in hand yourself. You can trust the word of your consumer. If they're telling you, yes, I canceled the listing, I signed a cancellation of listing, you can take their word for that. You don't have to have them forward it to you.
Well, we're hearing a lot of is like, yeah, I'm trying to cancel, but my agent won't let me out.
Right.
At that point, we're still hands off, right?
You're still hands off because when you think about it, right, a lot of people think about a real estate transaction between a buyer and seller, and that's a contract. That purchase agreement is a contract.
Yeah.
Well, the listing agreement is also a contract. It's a contract between the listing brokerage and the seller. And
listing brokerage, not the agent.
That's right, the listing brokerage. And if one party wants to cancel, it takes two to tango, right? And so they have to get both people on board to sign that cancellation. If either party, whether it's the buyer whether it's the seller or the brokerage, if either one of them is unwilling to sign, the contract remains, and we can't step in.
Got it. Yeah. So that's what we've just had to start telling people to do, because it's like, I don't want to get dragged into a code of ethics.
That's right.
Like hearing, or is that what they're called? Hearings?
Yeah, a grievance committee. Hearing. Yeah.
Because that's just So let's say somebody is called into one of these hearings or these committees. What happens? Like what can the agent expect?
Yeah, so a lot of times the complainant will draft something up and say, hey, here's what happened. They can provide documentation and whatnot. Before the committee even reaches out to the respondent, they review all that stuff, and they will add and delete certain provisions. So the complainant may say, hey, I think they're in violation of Code of Ethics Article 1, Article 4, Article 6, whatever it may be. And the grievance committee will say, well, no, 6 doesn't really apply here. But guess what? 8 does, and you didn't ask for that, but we're going to add 8 on, right? And so they go through and they do that, and then they send it to the respondent. And they say, hey, by the way, you've got a complaint. We need a response. The respondent has to put something together and then send it in, and then a hearing gets scheduled, essentially, where kind of think of it like court. It's not court, but that's kind of the concept. As you go in and you have to present your side, and the committee makes a decision.
I remember being, when I was a member of Sacramento Association of Realtors, there's all these different committees you can be on.
Yeah.
And a lot of people wanted to be on the grievance committee.
Yeah.
Because it's almost like daytime television. It's pretty interesting.
I can tell you from personal experience as a designated broker. So what happens a lot of times is not only does the agent get named, but then the designated broker gets named as well.
Oh, really?
Yeah. And so I unfortunately have to deal with it in my role a lot. And I genuinely do not think that it is a fair process.
Really?
I really, really don't. I mean, I've had grievance committees find against me and say that, you haven't performed broker supervision when there's no merit to that whatsoever. I mean, I probably perform more broker supervision than anybody else,
Yeah.
So I don't find that it's a fair process. I think that it's very subjective to the personalities of the members that sit on the committee, and they have
The
biases.
old fuddy-duddies.
Yeah, they have biases. I mean, it's the good old boys club kind of thing.
Yeah.
Yeah.
Yeah. So basically, if
they don't like the brokerage,
if they don't like the brokerage, they don't like the agent.
that's right.
Yeah.
Unfortunately, it's very biased, and that's just my experience. But I mean, hopefully, it's not like that for everybody. And I do think that there's probably really great committee members out there, but my experience has shown me that there is a lot that aren't.
I haven't heard, honestly, now I'm trying to think back. I have not, people who've gone through these grievance committee things, I have not heard anybody say that was a fair process.
Yeah.
Like nobody likes it.
Yeah. I don't think it's a fair process. And anybody can a consumer can file a complaint. It doesn't even have to be somebody who's a member.
Oh, really?
Yeah. And so we deal with those too, where consumers will go and they'll take the complaint. Yep.
Okay. So let's say you're a seller, you're trapped in this listing agreement.
Yep.
You want out. The listing agent broker says, yes, we will let you out. By the way, here's a list of people
Right.
who I showed the property to or that were in the property when I was marketing it. It's called the exclusion list, right?
Correct.
And then that homeowner, if they sign it, they are now committing to owing that listing broker number one, a commission if any of those people buy the house. Is that correct?
That's correct. Or they're related entities. So it could be that you're on that list and you say, well, my mom's not going to end up buying it, right? So if there's a related entity, it still applies to them as well.
Okay. Mm-hmm. So because I got in a little heated argument with somebody the other day, and I said, no, I am not responsible for paying, like my brokerage, Johnny, is not responsible
Correct.
for paying that other brokerage. I didn't sign anything. I didn't agree to that.
Yeah, you're absolutely right. The seller would be responsible for possibly paying two compensations.
Yep.
The listing agreement has a provision specifically addressing that, saying, hey, listen, if the seller can't pay two, then they can go back and work with the original agent that provided the exclusion list, and our agent won't work with the seller for this particular transaction.
Got it. Mm-hmm. So if you are wanting out, my recommendation is try not to get them to sign that exclusion list, because you might end up owing two commissions, or you might hamstring your current situation.
Yeah, we see it. We see a lot of stuff. We see the exclusion list. We see that brokerages will. Brokerages / agents will say, okay, well, I'll cancel early, but if you relist with another broker, my compensation is still going to be 1%, regardless of who the buyer is, right? So
you can do that?
Yeah, you can. Yeah.
You can cancel it and still have them owe a fee regardless?
Yes. Yeah. So you can
for a
build
period
them
of time?
for a period of time.
So like 6 months?
Well, it's going to be based off of what's in the original listing agreement. So there is a clause, a term in the original listing agreement that says if there is a cancellation, a withdrawal, whatever it may be, even expiration, there's a period of time that compensation can still be owed after that. It defaults to 0. So, but a lot of agents will put 30 days, 60 days, 90 days, things like that. They'll go in and they'll put a number in. So that's going to be the time period that it's based on.
Okay. So just make sure when you're canceling, you know what you're...
Look at that original listing agreement. Yeah.
Know what you're canceling and what you're going to potentially owe.
Right.
Should that property end up selling.
And so you talked about a few minutes ago how it's my cousin that's got a real estate license, or it's this or that. There's a ton of licensees in this state. A ton of real estate licensees. The vast majority of licensees do very few transactions. They don't have the expertise. They're working another job. This is kind of like their hobby or their side job, whatever. And that's fine. That's certainly their prerogative to do. But what happens is that now they're looking at a canceled listing and they're like, well, they had already mentally spent that money.
Oh, the commission?
The commission. Yeah. And so they're like, okay, well, I don't want to give that up, so I want to try to get something out of it. Right?
Mm-hmm.
Yeah.
Yeah, you're right. They don't do a lot of business, but there's so many of them.
There's a lot.
That it adds up to a sizable amount of business.
That's right. Yeah, just volume by itself.
Yeah.
Right. Yeah.
So be careful when you're signing those listing agreements. We at Made for More, we have the Made for More guarantee. You can cancel at any time. We don't do the exclusion baloney that other brokerages or agents may have. But something else I want to touch on really quick, Ryan, is the request for repair. So we spoke earlier about how every sale is an as-is sale.
Right.
But the buyer has the right to do their investigation, submit a request for repair. And then how I typically explain it to the homeowner is just because you want to sell this house as is, we're going to market it as is, the contract is as is. But let's say they bring to you a request for repair. At that point, you have the option to either accept, reject, or counter. You can do any of those three things. But if if it's a health or safety thing, we probably want to address that because buyer A is going to want that, buyer B is going to want it. If it's a lender related thing,
right,
they're typically going to want that.
Yeah.
How do you recommend structuring that negotiation so it's most beneficial to both the buyer and the seller? Like, what would you recommend?
Yeah, great question. And health and safety, like you just said, I think is paramount, right? Because we talk about, I deal with lawsuits and I deal with different things. That's the kind of stuff that ultimately might turn into litigation, right? Yep. So I always encourage sellers to be open-minded to health and safety issues, things that were discovered, because even though contractually they have the right to say, go pound dirt, right? I'm not even going to respond to your request. They have the contractual right to do that.
Yeah.
But what happens is now they're in possession of material information, and that material information now has to be provided to the next buyer, and to the next buyer, and to the next buyer. And it's eventually going to catch up to them, most likely, right?
Yep.
I mean, there's a possibility that an investor comes in or whatnot, but, they're going to want smaller,
less
offer
of a
price.
Yeah.
And so ultimately, the buyers and sellers are decision makers. It's our job to advise a seller to say, hey, listen, this is something that if you don't want to do it, don't do it. That's your choice. But know that it will likely come up next time as well. It's not going to be unique to this particular buyer.
Not only is it going to come up, but you have to disclose it.
You have to disclose it.
When they hand you those inspection
you as
reports.
The agent. So now you as the agent, you're aware. And even if the seller doesn't want to disclose, you have to.
Yep.
Yeah.
Legally. So this is not going away. We can't dodge this.
Right.
And this is whether or not, like, let's say somebody gave you a bid for $40,000 and you're like, my cousin can do it for 10, right? You still have to disclose that stuff.
That's right.
That doesn't mean that's what it's going to cost, but this is what you have been presented with.
Exactly.
So disclose. And then while we're on the topic of disclosing, what are some common things that aren't disclosed that need to be?
Things that repairs that a seller has done themselves where they think they've addressed an issue and probably very genuinely they probably thought that it was gone, right? So perhaps there was a leaky faucet that was dripping underneath the bathroom sink and they kind of just DIY fixed it themselves. They thought it was good, but they didn't realize that kind of behind the wall that leak was existing as well. Maybe there's mold growing back there or whatnot, right? Mm-hmm. And so they don't think to tell the buyer, oh, well, there was a leaky faucet that I fixed. It's all good now. Maybe they genuinely didn't even think about it, But what happens is inevitably now the buyer somehow discovers that. And then says, well, wait a minute, you did a repair. Now you're saying you did a repair.
I see the bubble gum over the hole.
I see the bubble gum. The other big one that we see too is when like a pest inspection has been ordered, right? A pest inspection's been ordered and the seller says, that's a hogwash. There's no way that I've got all this issue here, right? Yep. And so then they go get another agent, and that agent isn't aware that inspection exists, right? So they're not disclosing it.
Are we talking hypothetical here?
We're talking hypothetical here, right? That agent doesn't know it exists, and then what happens is the buyer now discovers an issue, whatnot, and maybe they called the pest company, whether post close of escrow, they happen to randomly call the same pest company, and they're like, "Hey, we were there 2 months ago. Here's our report. That gets sellers into trouble a lot because the buyers discover that something was there that wasn't given to them.
Sellers disclose. Just disclose. If you're like, should I disclose this?
Yes.
Yes. The answer is yes.
Yes.
And then deaths as well.
Yeah,
right?
Deaths. Any death in the property in the preceding 3 years has to be disclosed. Yes.
And what was it?
And then if the death was a result of HIV or AIDS, that also has to be disclosed.
Yeah. Again,
Yep.
We're not making these rules up. This
These aren't our rules. These are state laws. Yeah.
So the other thing too, and I want to get your thoughts on this, but there's a period of time where if a repair is made, the buyer and it fails, the buyer can then come back on the seller. And I want to get your thoughts on this and see if maybe I'm on the same page. Back after this.
Thinking about selling your home before the year is up, but you don't want to go through all those open houses and showings and getting things organized or all of those costly home repairs? Well, there's an easier way. Just reach out to Johnny Jennings with Made for More Realty, and he'll give you at least 3 cash offers on your home in as-is condition. So just Google Johnny Jennings with Made for More Realty and get more for your home.
This is Made for More Living with Johnny Jennings online at madeformorerealty.com.
So, we've talked now multiple times, Ryan, about how every sale is an as-is sale,
right?
But the buyer has the opportunity to, present their requests for repairs.
Yep.
And how I coach my sellers to handle that is if it's a health or safety thing, if it's a loan required, like a general loan required thing, you should probably address it.
Right.
But let's do this. Let's give them a credit.
Yeah.
And the reason why I tell them is because that shifts the burden of responsibility completely off of you,
spot on,
onto the buyers. Because even if they hire a reputable contractor, even if the seller hires a reputable contractor, it might even be who the buyer wants, and that repair fails.
Right.
What do you typically see end up happening?
Yeah. So if something fails, the buyer will then. We live in California. It's a very litigious state. They'll sue everybody. They'll sue the seller. They'll sue the listing agent. They'll sue the contractor that did the work. It's so much better.
The buyer's agent.
The buyer's agent. The buyer's brokerage. They'll throw everybody in there. And typically the brokerages get included because that's who has the pockets.
Yep.
Right. And so, yeah. I mean, is it a fair system? Not necessarily, but it happens all the time. But you're absolutely right, especially when providing a credit. I mean, even if it's not health and safety, let's just say as an example, the water heater needs to be replaced. The water heater's old and the buyer and seller negotiate to replace the water heater. I have seen situations where the seller says, okay, great, I agree to do it. They go get the water heater company to come out and they install like a Rheem water heater, right? A Rheem is a brand of water heater, right? And the buyer comes in and says like, I don't like Rheem. I think they fail. And it's like, well, it's in now.
Yeah.
Yeah. And so I always advise and recommend give a credit. If you're willing to do it, give a credit in lieu of a repair. Let them utilize that credit however they want. And most of the time, those buyers will take that credit and they won't even do the work.
Yes. I'm glad you said that. I was thinking that. They take the money and run.
They take the money and run, right?
Yeah. Oh my gosh, that's so true.
Yep.
And sometimes too, another reason why I prefer to do the credit is like, let's say something pops up on the pest inspection or the home inspection and they're like, hey, it looks like it's this.
Right.
But you never know.
You never know.
You might start opening things.
That's exactly right.
If it's a
Pandora's box, man.
Yeah, let's just isolate it to this situation.
Yeah.
Send them a credit, call it a day.
Yeah.
And you never have to worry about this house ever again.
Yeah.
As long as you disclose.
As long as you disclose appropriately. Yeah, because the buyer has, like you were saying, the buyer has the right to make a request repair or repair request, excuse me. But they also have an obligation. They have an obligation to do their own due diligence. They should be looking at those reports. They should be looking at those disclosures. They should be asking questions and making sure that what they are buying is something that they are comfortable buying. So many buyers, unfortunately, don't do that. They get emotionally invested in the property, right? And they're like, oh, this is going to be great. I love the school districts. I love that it's a walk to the park, it's real close. They just get emotionally attached and they even though this information is right there in front of them, they don't see it, and they don't ask about it,
or they don't read it.
Yeah,
in all fairness, these home inspection reports, they're easy to read, but they're long.
They're long.
They're like 50 plus pages.
Yeah, and I can tell you, I've been on a case where a home inspection report recommends all kinds of things. Every single home inspection, you can go to a brand new house, let alone a house that's 60 years old. That home inspection report, it's always going to find something, right?
Yep.
And I say that home inspectors, they're generalists, right? They're like your family practitioner for medicine, right?
Yeah.
You don't necessarily go to them if you're having issues with your eyes. You go to the optometrist, right? And so if you go to your family practitioner, they're going to say, you should go to your optometrist. That's kind of like what a home inspector is, right? They're generalists, and their report is going to have so many recommendations to see a specialist. And do buyers do it? Absolutely not, because every one of those recommendations is out-of-pocket cost, right? Now I have to go hire a roofer to come and inspect. Now I have to go hire a sewer lateral inspector to do that, right? And it's cost, and a lot of buyers either can't or won't do that. And then inevitably what happens is that something comes up post-close of escrow that could have been discovered with due diligence in an inspection.
On the buyer's part.
And they didn't do it. But they want to say, well, again, I kind of go back to the sewer lateral. We deal with that all the time. Those tree roots. How would anybody know? And so a buyer might say, "Well, the water was flowing slowly. You should have known that something was blocking." Right? But that's not really how it works. But again, we live in this state where it's easy to pursue litigation, and so it happens all the time.
Yeah. So if you're getting inspections done, read them.
Read them.
If you have a request for repairs, and just honestly send them a credit.
That's what I would say.
Negotiate a credit.
Yeah.
Matt, didn't you have a story about
Yeah,
somebody?
I want to get your thoughts on this. So I've heard this story many a times from my pastor. His name is Francis Infuso. He's not shy about sharing this. So he says this: a year after we sold our home, the new owners sued us, claiming they discovered mold and believed we knew about it. We didn't. So off to arbitration we went. The owners were so upset with us, they wouldn't meet with us in the same room. When we were presented pictures of the mold, it made us sick and sad. I then looked at the arbitrator and said, I don't believe we should give the owners what they're asking for. We need to do... Oh, and he said, because he's a pastor and he has a heart, he wanted to go above and beyond.
Oh.
But would someone in that same situation be obligated to pay retribution, or how would that case progress?
Great question. So the basic premise is the sellers are required to disclose what they are aware of or could be readily knowledgeable, right? So like as an example, you see that sidewalk by the tree, there's a big tree out in the front yard, and you see the sidewalk in front of it's kind of buckling up, and the water main happens to be right next to it. A seller should say that might be an issue, right? So somebody can make the argument that the seller should have readily known that was there. Mold is a much more difficult thing because mold, typically speaking, is in places that we don't see.
Yep.
And it's not something that it creates visual, components. And unless it's growing like on the wall and it's very apparent, a lot of times it's growing inside the wall and we don't see it. Nobody sees it.
Or in like the subfloor.
Or the subfloor or whatever it may be. And so in a situation like that, it's like, okay, well, yeah, there's mold there. He wasn't aware of it. I mean, if he genuinely wasn't aware of it, does he have a responsibility? Well, no. I mean, how can you be responsible for what you don't know? But I have dealt with situations like that have gone beyond arbitration and gone to jury trial, and where jurors have said, well, sorry, seller, this is on you.
Even though there was no possible way you could have known about this.
Right.
Sorry.
Yeah.
And
when
Is there a time limit? Like this happened a year later.
There is statute of limitations, so it depends on what specifically it is. And part of, like I was saying in that trial, right? Part of what the argument is like, well, how does anybody know when this actually took place?
Yeah, when did it start?
Right? Or even if it was present at the time and the seller did or did not know about it, if nothing's been done in the meantime, how worse has it gotten, right? And so I've seen situations where sellers have stayed in the house, right?
Yep. For years. They're suing and they're saying, this is horrible. My life is in jeopardy. What have you done? Nothing. Give me more money.
That's exactly right. But to answer your question, if he genuinely didn't know anything about it, should he be responsible? No, right? Because they bought the house. They had their due diligence obligation, right, to inspect the home. And even if they inspected it and it wasn't discovered, if the inspector's not discovering it, how would the seller know?
Yeah, how would the homeowner know?
Right?
Is there some type of mold inspection that a seller or a buyer can do or should do? No?
There are mold inspections that can be done, absolutely.
But you think that's just kind of going above what's necessary, or why are you laughing?
A lot of these inspection companies, they will not say the M word.
Oh, they won't.
Oh, yeah, they won't.
Yeah.
Yeah. I mean, there are mold
because they'll be
inspection.
liable.
There
right?
are mold inspection companies, but like a generalized like home inspector, they will never say mold.
Yeah.
Right? What they'll say is there
discoloration.
And why is that?
There are conditions.
But let's clarify why they won't do that.
Because they're not licensed to identify mold.
Yeah. So, and for clarity's sake, home inspectors aren't licensed at all. Pest inspectors are, right?
Oh, that's a good point.
Yeah, home inspectors are not. They get certified but they're not. It's not something that's regulated by the state. And so, for liability purposes, they say this looks like it could be something. You should go get it checked out. Yeah.
So this is kind of like Law and Order real estate style, right?
Yeah.
Judge Ryan instead
Ryan.
of Judge Judy.
Yep.
But yeah, so that was cool that Francis though said, "Hey, we're gonna."
Yeah, that's just
discover
in
it.
his heart. They wanted to go above and beyond, and just
Right.
They didn't have to, obviously.
Yeah.
From what you're saying, they weren't liable for that.
Well, I
but-
mean, if they went to arbitration, they likely had attorneys involved at that point.
Yeah.
And at some point, there does come a path of least resistance. That's why I was saying almost 90% of things get settled. They never make it to trial because at some point there is a path of least resistance. So the billable hours for those attorneys add up real quick.
They do.
Right?
The only person that makes money in that situation is doggone attorneys. But so as real estate agents, we have most agents, right, have errors and omissions insurance.
Yes.
Right. Is there something like a product like that for homeowners?
There are. I believe it's called real estate risk management companies. I believe that's how they title themselves. Where it's essentially you can kind of pay like a flat fee at the transaction, and it essentially becomes it's not insurance, but it's legal representation. It's kind of like prepaid legal, right?
Okay.
So that if something does come up, you've kind of pre-bought coverage for an attorney.
Interesting.
Yeah. So there are companies that do that.
Yeah. So I know I breezed over the term E&O, errors and omissions insurance.
Errors and omissions, there is such a misconception about errors and omissions.
Really?
Yeah. So, I'll give you an analogy, right?
Hey, can you give me the analogy after the break?
I'll give you the analogy after the break.
If a movie has a 100% Rotten Tomato rating, you can be sure it's going to be a pretty good movie, right? Well, that's the case with Johnny Jennings and Made for More Realty. No, they don't have a 100% Rotten Tomato rating, but what they do have is over 1,000 5-star Google reviews. So it's pretty evident that a lot of people love the job that they are doing when it comes to helping them sell their home or purchase their next home. They're friendly to talk to. They're also very professional and can get things done fast and for the most money possible. So if you would like their help, they'll walk you through every step of the process. No problem, easy. That's why they have, again, over 1,000 5-star Google reviews. Just Google Johnny Jennings with Made for More Realty and get more for your home.
This is Made for More Living with Johnny Jennings online at madeformorerealty.com.
All right, so we're back. The analogy that you were going to cover.
Yeah. So with errors and omissions insurance, the analogy I say is if you have a car, right? You have car insurance. You're insured, right? Now, some insurance companies have like uninsured insurance that covers you so that if you get into an accident with somebody that has little or no insurance, right, your company will cover that.
Yeah.
But you're the covered person, right? Errors and omissions insurance covers the brokerage and the agents. But a lot of people say, well, I just want to go make a claim against E&O. And it's like, well, that's not how it works. We're the insured. We make the claim, right? We're the ones that if something is going on that we feel that errors and omissions needs to come in, we can make the claim against it. But the average Joe on the street that feels wronged, they can't do that, right? But a lot of people do. We get a request all the time for, send us the contact information for your errors and omissions. It's like, well, that's not how it works.
So why would they be wanting to make a claim, or who would be?
Yeah, so like maybe a consumer feels that their agent did something wrong, didn't disclose, was unethical, XYZ, and it resulted in the property having damage. Who knows, right? There's all kinds of different things, and so they'll say, well, give us your errors and omissions insurance. It's like, well, no, we can address the issue, right? We can talk to you, whether it's through legal channels or settlement, or we can tell them to go pound dirt, right? We do that a lot too. But our errors and omissions is not for the consumers; it's for us, and we choose when we want to bring it into play. Our internal in-house counsel, right, chooses if it makes sense to bring E&O in it or not. So
yeah. Okay, that's interesting. I did not know that people were like calling you up, like,
yeah.
Hey, I want to make an insurance claim.
All the
Pay
time.
me out.
All the time.
Really?
All the time. I had one just yesterday.
Okay.
Yeah.
Well, there was a story Matt was sharing with me about how this person, was it in San Francisco, Matt?
Yeah,
Like
where was
San Jose,
Sunnyside? Yeah, so the Bay Area.
Bay Area.
So what is your thoughts on political discrimination? A landlord listed a 2-bedroom apartment in Zillow, and he said MAGA voters and Israel supporters only. And he got a lot of backlash from it, saying, hey, that's illegal. You can't just restrict your open house or the sale of your apartment to a certain demographic of political ideology. That's illegal. Are they right? Was he breaking the law by posting that on Zillow?
No. So I think probably what people are thinking of is protected classes. So there is fair housing protected classes, and that list is relatively large.
Yeah, I have it pulled up right now.
Yeah, political affiliation, as far as I know, is not on that list. I could be wrong, but I'm 99% sure.
No, there's no political
affiliation. I mean,
there is age over 40.
Yeah,
so you're in a protected class.
Well, I am too.
You are too.
Watch it, John.
Oh man, hopefully I'll make it there someday.
You know, a seller it's their prerogative to sell to anybody. It's very subjective, right? Because it could be that, yeah, you might be making an offer at the price that I listed it at, but you're also asking for, credits for this or that, and so there's so many things, and it's subjective, and so the seller, it's well within their right to reject anything. Now, what gets sellers in trouble is that somebody may say, well, the reason you rejected my offer was based off of a violation of fair housing, right? You saw that you saw me going into this particular church, or you see that I'm
an interracial couple,
right? And so you made your decision not to sell to us based off of that, as opposed to anything else, because we gave you such a great offer, right? It's hard to say what that seller's decision was based off of. It's subjective to just them. Were they genuinely violating fair housing? Possibly. Right. But maybe there is another factor that's in there that isn't in. But what happens is now the sellers find themselves on the defense, right? Because now they have to show that their decision wasn't based off of that.
So do you recommend agents show their sellers those client letters?
Buyer love letters, I highly, highly, highly discourage it. And for this...
They work, though, from what I heard.
They do. People wanted to tug at heartstrings, right? But what happens is, let's say that there's a couple of different... Or even if there's not a couple of different offers, Johnny and Valerie write an offer on my property, and they put a buyer love letter. They have the picture there with them and their kids, and it's great. And I, the seller, don't choose their offer for whatever reason, right? I didn't like that they wouldn't give me the rent back that I wanted, whatever it may be, right? But now they say, well, you didn't choose our offer because we sent you a letter and, you don't like family. Your family values are not good, right?
Yeah.
And so those buyer love letters are inevitably a pathway to fair housing violations, even if it's unintentional. Right. And in fact, the listing agreement defaults to saying that if those are received we, the agents, will not give them to you. The seller has
I'm glad you bring that
the
up.
seller
Because
has to sign.
we'll split the PDF.
Yeah.
And we'll remove it.
Yeah. So
Really?
Yeah. Exactly.
Wow.
So if the
I'm
seller
not going into
wants
court
them,
because they're not just going to sue the seller. They're going to sue me too.
they're going to sue you too. And so if the seller wants those love letters, they have to specifically sign in writing on the listing agreement acknowledging that they are directing us to provide them
But
to
do you
us.
tell the other agent or the other buyers that, hey, we're not going to share that story?
Yeah, absolutely. There's
I don't say jack.
yeah.
I just like, hey, thanks for the offer.
I'm taking the fifth. I didn't know anything.
Yeah.
Yeah, there's no obligation to, but I'm not opposed to it. I'll be like, hey, by the way, the listing agreement says that these love letters are not going to be presented.
See,
so
but you have a law degree. I'm fishing in the dark here. And I'm so nervous. I'm just like, I'm not saying anything. So, okay. So that was interesting though.
Yeah.
So he was not apparently,
So he was-
but
so-
there is a protected class that often gets people in trouble, that they're not aware of, right?
Veterans.
Veterans.
Yeah. So in this business, historically, agents have made a presumption that VA loans are underwritten in a way and appraised in a way that is detrimental to the seller. And so agents will tell their sellers, hey, we have this conventional loan and this VA loan, and they are exactly the same, but you're going to have a headache with the VA appraiser.
Yeah.
Guess what? They just violated fair housing, right? Because veterans are a protected class and they can't direct.
But I'm not not accepting the veteran. Just come back with a better, what's the difference between FHA or conventional? Like, hey, give me your conventional offer. Give me your cash offer. Like, I'm not.
Right. But let's say the offers are exactly the same, with the exception of one is a VA loan and one is a conventional loan, right? Every other term in there is exactly the same. And if the agent says you don't want to deal with the VA loan because of the underwriting, go with the conventional, they're violating fair housing.
Well, can you just tell the VA, hey, don't get a VA loan, go get a conventional loan, and I'd entertain it?
No.
Really?
You're violating fair housing.
But it's so weird. It's like
they have every right to
I'm
use
violating
that
the
VA
financing.
benefit. But it's a benefit. It's a benefit of being a veteran.
Really?
Yeah. And so if you're saying, hey, listen, if you go get a conventional loan instead of a VA loan, you are violating, whether, I'm saying that in a general term, not necessarily you, Johnny, but like a seller, right? Or whatnot. Anybody says, go change your loan type and I'll accept it.
Yeah.
You're violating fair housing. Yep.
Interesting.
Mm-hmm.
Well, there you go. Mm-hmm. So words of wisdom there. And then I got a funny, that reversed maybe discrimination clause.
No.
Or story. So there's this guy, he was wanting to sell his house, and we weren't working with him. He reached out to us because he was frustrated because his house wasn't selling, and we're like, oh no, and so one of my guys relayed the story to me, and he's like, what happened? Like, are you still listed? And he's like, yeah, I was listed. We were in contract. We were scheduled to close, and then all of a sudden, the family comes out to do their final walkthrough, and my neighbor's standing out in the front yard watering her grass, and she was wearing her outfit. And I'm like, what are you talking about, outfit? He's like, well, uniform, because she's in law enforcement. She's a correctional officer. And they thought she looked like she was a ICE agent.
Oh, boy.
And so they thought she was an ICE agent, so they pulled the plug on the deal.
Oh, wow.
So is that any form of discrimination, or is that like...
Well, it's the buyer, right?
Yeah.
The buyer, when you talk about buyer investigation, I mean, if you're at that point, you're pretty much past investigations, but... An investigation can be anything. I can walk into the house Friday night at 6 o'clock and the shadow on the wall gives me the heebie-jeebies, right?
But like I'm not allowed to steer people, like redlining, like things like that. But then can the buyer make, let's say, racist or protected class decisions themselves?
Well,
and purchase the home?
A buyer can choose to buy or not buy anywhere. If the buyer says, I only want to live in a certain type of neighborhood, that's their choice. But what can't happen is the seller can't say, well, I'm going to prohibit, I don't want somebody an interracial couple, as an example, to live in this neighborhood, so I won't sell to them.
Isn't that interesting, though? So the seller can't pick, but the buyer can pick.
Yeah, because it's the buyer's right to choose to live wherever they want to live. So it's they have the option. Right, but the seller does not, because it's discrimination to the buyer. The seller isn't being discriminated against because the buyer doesn't want to live in that neighborhood, right?
Well, they're not getting the sale.
What from that particular buyer?
Yeah.
from that particular buyer.
But I just thought that was interesting.
Yeah,
They were like, "Oh no," and so I'm like, "Oh, that's kind of reverse, but not really." But the last thing, because we are running out, is what? Actually, I was going to say something else, but we do not have enough time.
You do. Just keep going.
Just have some time.
We have plenty of time. We have a little bit of overtime.
So sometimes things close, and then people move in, and there's issues, and then the agents are contacted by their previous clients.
Yeah.
What responsibility does the agent have? Like, what should they do under those circumstances? The transaction is closed.
Great question. So there's really two answers to that. So from a regulatory standpoint, agency relationship ceases upon the close of escrow. When the sale is completed, agency relationship is over. We're licensed to conduct real estate activity. Disputes are not real estate activity, right? So from a regulatory standpoint, what we should be saying is, hey, listen, we're not attorneys. You should speak with a qualified California real estate attorney and understand what your options are, because we can't advise on that, and we can't help with post-close disputes. But the other element to take into consideration is that we work in a profession that is built on reputation, right? And not just reputation, but a lot of times agents make long-lasting relationships with these clients, right? They become friends.
Absolutely.
Right? And so it's not so easy to tell your friend now, oh, well, I can't help you. And so what agents do a lot of times is they do try to, at least on a surface level, see if there's a resolution that can be had or that they can assist with. But our advice as a brokerage will always be they need to go talk to an attorney, right? Because we're not attorneys. Yeah.
So you would be okay with the agent stepping in trying to figure that out? You would recommend that, or you?
I will always tell agents our advice to them is going to be this. But I will also say, hey, listen, if the buyer, we represented the buyer and the buyer wants to get some information over to the seller, help navigate that, right? Contact that listing agent, see if you can get that information. There are ways that we can, help to facilitate to a certain way, but I will always caution agents not to go too far down that bunny hole.
Oh my gosh.
Because inevitably they will get looped in. So it's like, hey, kind of surface level, right? Hey, Mr. Listing Agent, my buyer is having issues. Can you pass this letter on to the seller? They're trying to get in contact with them, stuff like that. Totally, totally okay. But if you start trying to negotiate it and saying, I have seen agents that say, well, you're breaking the law. You're doing this or that, and you're open to litigation. It's like, well, how do you know? You're not an attorney. You may be practiced in this profession. You may have knowledge, but unless you are an attorney, you don't really know what this is going to boil down to.
Yeah.
Right? Yeah.
Absolutely.
Yeah.
Well, my friend, it was an absolute joy having you on the
Thank
show.
you.
Thank you for coming on. We got to get you back on here before too long.
Yeah.
It was way too long.
It's been probably a year. Yeah.
It's been a year. We got to do it more often.
Yeah, for sure.